The language of the statute says sex. It says that we have to look at individuals. And the fact is that the courts who are trying to decide these cases that are being brought by sexual minorities are having a harder and harder time distinguishing between their status, whatever it is, and sex.
Hi there.
Hey.
Hey, Liz.
So I'm excited to talk about your amicus brief. So, Marcia, can you tell us about the plaintiff in this case?
Mr. Zarda was a skydiving instructor, and the way that sort of the case arose was that he helps people by doing tandem jumps with them. So a person would be strapped to him and they would jump out of a plane together. And he would be sort of the expert so that the person didn't get injured. And he was being teamed with a woman who was there with, I think, her significant other. And he said something to both of them, like, don't worry, because the woman was going to be the person who was strapped to him. Don't worry, I'm gay, to sort of alleviate any stress or concerns about the fact that that this woman was going to be in very close physical contact with him. And shortly after that, he was fired by the skydiving company.
Have you ever been skydiving?
I have not, but my oldest kid, when she was like 4 years old, said that she, when she turned 18, she wanted to go skydiving. And my spouse and I joked like, oh, ha, 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 sure. And then she didn't forget. So there is a slim chance that one of us will be skydiving relatively soon.
Oh my gosh. What about the rest of you? Have you gone skydiving?
I'm very risk adverse. So
yeah.
That's not in my future.
Yeah, me too. No skydiving for me in the near future.
Can you tell us more about the legal question that the Supreme Court is going to try to answer in this case?
Yeah, so the question is what is the relationship between sex discrimination and these other forms of discrimination, gender identity discrimination, and sexual orientation discrimination? And the thrust of the cases that have come up or been percolating in the courts before is, whether someone's sex is inextricably linked to their sexual orientation or gender identity, so much so that you can't discriminate against someone because of their sexual orientation or because they're transgender without taking their sex into account. And so, that's really the question. Can you separate these things out? The employees here will obviously say no, that there's no way that you can disaggregate the two from one another. And a lot of the arguments we've seen from the other side, particularly from the federal government, the Department of Justice has talked quite a bit about legislative intent and legislative history, and this is not what sex means, right? The meaning of sex is men and women, but that's an issue that was litigated in the 1970s and 1980s, where the federal courts took a non-individualistic view of what it means to discriminate against because of sex. So they saw these things as being, if you're discriminated against because of your sexual orientation or your gender identity, that's a group, and that's different from being a man or a woman. Where courts recently have said, no, you can't separate those things out like that. You have to look at the individual employee and how their sex as a trait plays a role in the discriminatory or the allegedly discriminatory act.
I mean, what would you say to maybe a conservative member of the court who says, you know what, Title VII doesn't have a sexual orientation in it, and if you want Title VII to protect that, Congress should add that language?
I'd say a couple of things. One, which is in the brief, the language of the statute says sex. It says that we have to look at individuals. And the fact is that the courts who are trying to decide these cases that are being brought by sexual minorities are having a harder and harder time distinguishing between their status, whatever it is, and sex. And so the fact that the courts can't figure this out and it's becoming more and more clear means that this is what the statute does.
Mm-hmm.
So if I were talking to one of them, I would first say, well, let's talk about textualism, right? And if textualism means what you as judicial conservatives and legal conservatives say it means, then I think this is an easy case.
I mean, what is the textualist argument that you would make?
Well, I think it's, right, it's clear. So if I would probably, just for the benefit of ease, right, I would probably do a kind of but-for analysis, right? If you are, right, if you're a woman and you're, so you're married and you're dating Steve, and that's fine with your employer, right? But, all of a sudden you're Martin and you're dating Steve, and that's a problem. The only trait there that's changed is your sex. And of course, right, there's a whole bunch, right, all this sex stereotyping doctrine that comes in, and some of the courts have looked at some other frameworks, but you really don't have to go through the kind of calisthenics, the logical calisthenics that Marcia was talking about, that other courts have done before, where they're trying to do this, this bean counting of, well, how many times did you get this slur thrown at you versus this, and so maybe this is this kind of discrimination, or where courts in fact have said you get a protection because you're actually a heterosexual and you were presumed to be a non-heterosexual, so you get the coverage. But if you were actually an LGBTQ person, sorry, you're out of luck, right? So that kind of absurd result can't stand.
Yeah, it means the courts don't have to do the weird line drawing that they're doing now, where they're trying to say, okay, well, was this particular bad thing said to you because of, this trait or that trait? I mean, anything that's even arguably connected with a person's sex, sexual orientation, gender identity, gender expression, sex-linked behavior, any of that kind of stuff now, it's just, okay, if you were penalized for it, that's sex discrimination. And so it just makes the rules clearer, frankly.
I guess one of the things that I think I'm struck by is, the idea that, like, when you protect people on the basis of sexual orientation, you're also kind of protecting everyone in a way, or protecting the freedoms of a much broader group. And I was wondering if you agree with that and what your thoughts are on that.
Statutes that prohibit sexual orientation discrimination provisions, they protect gay folks and bisexual folks and lesbian folks, but most of these statutes are focused on the individual. So just as Title VII protects white people against discrimination for being white, and you necessarily would have to read sexual orientation discrimination protections to protect heterosexuals.
Well, and to go to your point too, right, that LGBTQ people are people's parents and their brothers and sisters and right, their spouses and right, there's friends and neighbors, and so having a system where people can be arbitrarily discriminated against in the workplace is not good for the stability of any family or any neighborhood, right? So we don't want that, and it's not good for companies either, and that's I think why so many companies have signed on to another amicus to support it, because companies recognize that diverse workplaces are better.
I mean, it's some of this about privacy. I mean, on this show, we've talked a lot about like how much an employer can like meddle in, your political life, your life offline or whatever. I mean, is some of this also just about privacy?
In the Zarda case, it wasn't some issue about whether it was private information that he was gay. He said it.
At least in the kinds of places I work now, although I worked plenty of retail, don't usually like ask, so who are your romantic partners? Who are you dating? Who are you going out with? I get to keep that stuff secret. And so if it's irrelevant to the employment decision, then maybe it's more likely that everybody will be able to keep that stuff secret.
Mm-hmm. But there's also a public citizenship aspect to this too, where so many people, right now. So, for example, if people are perceived as being, gender nonconforming, right, we've developed this quirky system that we've talked about, where the courts have provided some remedies for people who might be seen as a little too effeminate, and then that might start some prying into their personal life and accusations and labels thrown and all the rest. But there's also that element of people who work in places where where their sexual orientation is not known, where they might be LGBTQ and no one thinks twice about it, or no one thinks to pry into that, right? So the privacy there is kind of the default, and the person wants to be able to be true to who they are in the workplace as much as they are, right, in the public square, right? And I've known plenty of people in North Carolina, for example, where they're afraid to go on dates in certain places because they know that's where their employers and their coworkers go and associate, right? So they're denied a whole kind of public citizenship because they're forced into that privacy, that very private default. So I think it does an important work on both ends to keep the privacy element there and reinforce it for those who want to have their lives private and not talk about it, but also let people be their true authentic selves in all public spaces, so that without having to fear some kind of adverse employment action in the workplace.